I'm Brian Bird, Senior Program Officer here at the New York State Health Foundation, and welcome to the latest installment of the Foundation's Practically Speaking. Today we're going to talk about the fundamental social determinant of health, housing. Specifically, we will discuss evictions and its growing public health threat in the age of the COVID-19 pandemic. The New York State Health Foundation has always believed that the nexus of housing and health is a vital component to a robust and public health ecosystem. As the pandemic rages on, with over 202,000 deaths, housing and sheltering in place is still considered one of the best defenses in fighting COVID-19. So much so that Governor Andrew Cuomo and the Centers for Health Disease Control, CDC, both issued moratoriums on evictions. But what does this mean? What do moratoriums do to protect the most vulnerable? Or is this simply kicking the can down the road only to set us up for another public health crisis? And before we go on, consider this. A new CNN analysis of data from the Eviction Lab at Princeton University Research Institute found that neighborhoods with elevated rates of medical conditions that put people at risk, more at risk for serious illness from COVID-19 have seen disproportionately high rates of eviction filings over the last 6 months. With us today is Laura Roenick, Director of Evictions and Reentry Programs at the Volunteer Lawyers Project of Onondaga County. She will give us a brief presentation on eviction moratoriums, and then we're going to have some time for questions from our audience. Since the video and audio are disabled for attendees, please type your questions into the chat box and I will read them out. And as always, just like the previous webinars, this webinar will be recorded and sent out with a recap. And now, Laura, over to you.
Thank you so much, Brian. Thank you to the New York State Health Foundation for having me here today. Hopefully we can clear up some things for people. And thank you also to Stephanie for coordinating this and making sure everything runs so smoothly today. So briefly, as Brian said, I am the Program Director for Eviction Defense of the Volunteer Lawyers Project of Onondaga County. Onondaga County is in Syracuse, or Syracuse is in Onondaga County. And in the city of Syracuse, in any one given year, about 5,000 eviction cases are filed. Around the country, in any given year, 2 to 3 million eviction cases are filed, and that's obscene and huge. Due to COVID, they were expecting up to 24 million eviction cases to be filed nationwide, a huge tsunami. So briefly today, what I'd like to do is give you a quick overview of how evictions happen, what are the bases for evictions in New York State, what the COVID-19 responses have been, and where things stand today, and then we'll do a more extensive Q&A. So this is going to be a brief overview, and then we'll get to your questions. So what I'd like to do is, first of all, let everyone know a little bit about, I'm going to share my screen. There are basically 2 types of eviction cases. Am I sharing the right screen? Okay, so the first is called a holdover case. It means that a landlord gave someone notice to end the rental, terminating the tenancy, or they're claiming that there are lease violations. The most common is for non-payment. It's always cured by making the payment in full. Both require due process and steps and notices along the way. And why I think it's really important for everyone to understand this is that most people don't, and it impacts how the various moratoriums will come into play, and we'll get into that. So remember, non-payment's the most common, but holdover is about 15%, and what we expect to see is that those may change and get, the holdover cases may become more common. The Tenant Protection Act of 2019 that went into effect of June of last year showed that, or changed the eviction timelines. So what I said before, notices are required, and if there's a non-payment case, it used to require a 3-day demand, they file and serve at court, they would get 5 to 7 days notice of court, and then a 72-hour warrant to vacate the property. So it could be a complete turnaround in 11 days. The legislature made that much more expansive and gave more time in the process, which reduces anxiety. It gives people a better opportunity to transition if they need to a new place, and more opportunity to figure out if there are defenses available or to come up with the money to rescue the rental. Also, as part of the act from 2019, which changed just about everything, it changed holdover laws. And everyone used to know 30-day notices. 30-day notices were what people got or what they gave to their landlord if they were going to vacate. But now the notice to a tenant is based on how long they've been there. 30 days if they've lived there less than a year, 60 days if it's been 1 to 2 years, and 90 days if over 2 years, even if they're a month-to-month tenant without an ongoing lease. So that's important to know, because what we suspect is that we're going to be seeing more holdover cases based on the fallout from the protections put in place. What are those protections? The COVID-19 eviction moratoriums are exactly like Brian said, and as analysts around the country have seen, it's basically kicking the can down the road. But the way that they've been announced to the public, I believe, has been very misleading, because most of our politicians love to say, we've stopped all evictions. We're not going to be evicting anybody. You know, if you owe rent, we're not going to hold that against you. The problem is that it's putting that down the road when someone is having a rough time affording the rent now and it keeps adding up. It's going to make it harder and harder. And the moratoriums themselves are not quite as clear as people would like you to think. So the problem that I see with moratoriums is that people misunderstood and thought the rent wasn't due, but it hasn't been waived. And so nationally, they're expecting a tsunami of evictions, right? A huge amount of evictions eventually. So what are we doing to protect against that? The CDC put out an order September 4th because of the public health concerns related to eviction. If we're evicting people from their homes where they currently could stay safe and protected, ideally from this virus, we'd be throwing them out into shelters and into communal living arrangements that are dangerous and where the virus can spread more quickly. So they issued a temporary halt on evictions through December 31st. But it is only for those cases where they've had financial hardship due to COVID. So it's only those non-payment cases. It doesn't necessarily stop a landlord from giving one of those notices to leave under a holdover type of eviction. And it allows the court cases to continue, and it basically creates a defense. And in New York State, we have our Tenant Safe Harbor Act. The Tenant Safe Harbor Act doesn't necessarily do what we would, if we've been led to believe, either. So I am going to stop sharing for a minute so that we can just talk to each other about this a little bit. The Tenant Safe Harbor Act, which, you know, there are so many other administrative orders from the courts that have interpreted this for the courts. There's lots of different things in play, but essentially the Tenant Safe Harbor Act provides that no warrants of eviction for non-payment can be issued during the COVID-19 covered period, which is whatever the governor basically says it is, as long as we have a state of emergency, or as long as there is any limit on gatherings of any numbers of people within the county of where that property is. So if it's against any residential tenant or other lawful occupant that has suffered a financial hardship during the COVID-19 covered period. Again, they have to have suffered a financial hardship. They have 4 factors that they can use to prove that, but it requires it to be done in court as a defense, and the landlord may still get a judgment for the amount of rent due. A lot of people are surprised by this, because when we hear eviction moratorium, we think, well, that means I don't have to pay the rent. And the CDC and the Tenant Safe Harbor Act both make it very clear that the rent is still due. Rent has not been waived. So if you're curious about that, or you have clients or people that you're working with, remind them that the rent is still due, that the Tenant Safe Harbor Act does not waive it, And the CDC Act specifically requires that tenants present a notification to their landlord that they believe they qualify, and in that, which they sign under penalty of perjury, they acknowledge that the rent would still be due. So if a tenant is facing eviction or is having a rough time paying their rent, we really recommend that they get the CDC form out to their landlord, and we'll give you the link to that in the materials for today. So that it's also just look up CDC eviction form. It comes up really quickly. It's easy to find. But what we have found as an organization is that we are almost as busy as ever, even though they aren't technically allowed to evict anyone, but we are still in court. And people are surprised to hear that, because the courts are hearing the cases that came in before COVID started, and they're just doing conferences, and under the Tenant Safe Harbor Act, a landlord could still, in theory, bring a holdover case or say, I've just given them a notice to terminate. So a defense is required, and they are still hearing cases. And we don't know exactly how this is all going to play out or look in the near future with the courts, and how they're going to deal with the fact that just yesterday, the governor made another announcement that the executive order, which is actually the Tenant Safe Harbor Act that he signed, but he called it the executive order, has been extended, the Safe Harbor Act, but there are no details available yet, and the order itself has not yet been published. So that was yesterday. We don't know today exactly how that's going to play out in the courts, but just know, I would strongly suggest that you keep up on this, and if you have questions, that you reach out. Legal agencies and legal aid agencies are available, and know that things are changing, very rapidly. The other thing that we're seeing in our agency a lot of is that landlords are frustrated because they haven't gotten their rent, many of them, for a long time, because people are suffering because we've lost income, and people who are frustrated sometimes take actions into their own hands. And so we're seeing a huge increase in landlords who are taking self-help eviction actions. And across the state, in the past, the police and our law enforcement agencies would sit back and say, well, landlord-tenant, that is a civil matter. We don't get involved. It's not a crime. Well, another great thing that happened, I think it's great because it's protecting tenants across our state right now, is the Act of 2019 added a provision that self-help eviction actions are now a crime. Any person who takes self-help eviction actions can be found guilty, not just a landlord or an owner. It could be a lawyer, it could be a maintenance person. If they are found to do things such that would encourage people to leave the property without going to court, the things such as changing the locks on the property, putting things out on the curb, turning off power, turning off water. Those are called self-help eviction actions, threatening the tenants to leave, really harassing them to leave. And the penalties are up to a year in jail and $1,000 to $10,000 per instance. And the Attorney General's office has put out guidance for law enforcement agencies that's pretty clear on all of that. And we'll encourage them, we hope, to help protect tenants during these very difficult times. It's stressful for everyone, but particularly for people who are at threat of losing their home. So I think that's a very quick 10-minute update, and I'm happy to answer any questions.
Great, Laura. That was fantastic. Thank you for that. And interesting, the questions are coming in pretty fast and furious. One of them, and this is exactly the reaction I had when I started reading up about this. So you can answer this.
Yes.
One attendee has said, you mean the rent is still due in the future? They must pay when the pandemic is over, or when they no longer have a financial hardship. Is this correct?
That's a good question. So in New York, they may get a judgment for the rent that is due. And a judgment is just what it says. It's a court judgment that the money is owed and that can remain open, but it cannot be used as the basis for an eviction in New York State. So any rent that's due during the COVID related time, they could get a judgment, but they can't get the eviction. And under the CDC Act, it basically said that as of January 1st, if all the rent wasn't paid, that they could be evicted at that time. So that's nationwide what these states are facing. And the tenants are facing. So unless we see some action to get more rent money out to people or to the landlords to help pay them back or some sort of relief, we're worried that it's going to be a very difficult winter.
Okay, and I actually have a follow-up question to that one. So is this true, or maybe it's false, that landlords can still add late fees and interest to unpaid rent to tenants' bills?
The original executive order, okay, like every day we're getting new executive orders, right? But one of the executive orders did state that through August 20th, late fees were not supposed to be charged to tenants, but that particular order has not been extended. So I'm thinking that our legislature might have thought it might have been an oversight because there have been so many changes, but right now they are not supposed to. And in New York State, a tenant may not be evicted for fees and late charges. So even if they are tacked onto the bill, an eviction for non-payment can only include the rent itself.
Okay. We have another question. What happens when someone's lease is due to be renewed, but people have not paid rent due to financial hardship? What are clients' protections?
The number one thing I do right now is get that CDC form and look at it. And if it is to be signed under penalty of perjury, and it's federal perjury, so make sure that you feel that you qualify for that and meet the qualifications. And if so, you sign it, get it to your landlord, document that you got it to your landlord, and keep a copy. So that's the number one thing to get you through at least December 31st. And also be prepared with documentation of your financial hardship, your situation before COVID and during COVID, because it could end up in court where you'd have to defend that case.
Okay. Another question. So if clients are receiving 14-day pay or quit notices from landlords, what should they do?
The two words that keep lawyers in business, I think, are it depends, right? It depends on your situation. You cannot be evicted for that non-payment if it was due to financial hardship. If, however, you had a steady stream of income that didn't change during COVID, say you were receiving disability benefits or SSI, you will not have that Tenant Safe Harbor Act necessarily as a defense. So again, I would check out the CDC form, and the other thing to note is that no one can make you leave your property without a proper court order, which is why I put the thing in the little presentation about self-help evictions. That's where this comes into play. No one can make you leave without a court order because they would be doing a self-help eviction action. They can't lock you out, they can't force you out, and so you want to stay. If that's your home and you don't have anywhere else to go, you stay and get all the defenses possibly available to you, and tell your landlord that you're experiencing financial difficulty, and definitely contact local legal service agencies in your area to see whether they might be able to assist you. And if it does go to court, try to get help. Ask the judges to be assigned an attorney if at all possible, because we're trying to increase the number of tenants who have representation in our state, because it's a confusing, difficult process at court without help.
Okay. And another question that I have is, so what would one do as far as with the police are concerned? Because a lot of times when these things escalate, you may have an officer who wants to do or wants to be able to help, but doesn't know what he's allowed to do. So in other words, if there's an illegal eviction that's going on and the landlord has called the police, what can we do to inform the police forces so that they understand what tenant rights are?
Absolutely. Write down RPAPL 768. First of all, that's the law that makes it a crime. And to reinforce with the police that that is a crime and that it's something that they could enforce, talk to the district attorney in your area, and look at the state attorney general guidance to law enforcement agencies that was published in May, which I also have a link to in the materials. And you can actually print that out and give it to the police if they're coming and say, here's what's happening. I want protection. Can we call the DA's office? You know, whatever it is that you need to do in your area. And you're right. Some law enforcement agencies are not comfortable with this because it is new and they're not used to having to take action to protect tenants' rights. But it's so important right now. It's so important. You know, we're hearing these cases by Zoom, and if you know, John Oliver did a thing about evictions this summer where he was saying, you know, it's ridiculous. We are evicting people from their homes by Zoom, which is a platform that we're only using because it's not safe for them to leave their homes, right? So it's not right. And so New York State thankfully has more protections than most other states at this point, but it's not a fail-safe.
Okay, I have another question. I work in an affordable housing unit in Rochester. Management is issuing 30-day eviction notices for non-payment in spite of the Tenant Safe Harbor Act and the CDC Act. The notices don't seem to have any teeth, but residents don't often understand that part. I'm concerned residents will start leaving out of concern for potential eviction. Can management continue to issue eviction notices during the moratorium?
Yeah, they technically can. I would be notifying them about all of the laws and you know, making sure that they understood that these are not people who can be evicted. I think part of the problem that we see sometimes is that landlords don't know about the financial hardship that people are facing. And so this is a time where it's actually really important to explain to the landlord that you have the financial hardship due to COVID, because that is what the protection lies under. And if you feel that you qualify for that, you know, get that information to the landlord to stop it and, you know, document it, and then understand that this may eventually end up in court. Now, the court's not hearing cases that have been filed since COVID started. So right now, statewide, new cases are not even being heard at the court, but they are accepting filings. And we don't know when they will start to hear new cases again. Right now, they're clearing up their dockets from the pre-COVID. And I haven't gotten verification of this yet because I haven't published it yet. But my understanding of the governor's order from yesterday is that it may also prohibit evictions based on the warrants of eviction that were issued before COVID. So it may actually protect some people in the pre-COVID world that we weren't sure were going to be protected. And in fact, I've been hearing cases on right now.
Okay. Next question. What happens if you owe expenses prior to COVID and start paying them but can no longer do so due to income decreases? So
well, depends on what type of expenses, right? Document it, do the best you can, get the CDC form out, and you know, document your financial hardship and know that you may end up having to do that at court.
Okay. Do tenants in illegal basement units have any protections under Safe Harbor or CDC moratorium?
Yes, and it depends on how long they've lived there. So if you've been somewhere in for more than 30 days, you get all the protections under the Illegal Eviction Act, the RPAPL 768, and the type of unit. If you're paying rent, you have protections. Whether if it's an illegal basement unit, you really may want to call the codes department and make sure that that it qualifies and is safe for you. But yeah.
Okay. Let's see. Here's one. So who is not protected by these moratoriums?
Who is not protected? Very good question. People who have not suffered a financial hardship due to COVID. So specifically, that's what these moratoriums were designed for. So if your income has continued, but you haven't paid the rent, you are going to end up with a judgment that for the back rent due, and you would have 14 days to pay that or be evicted. And that's how it works in the long run when that starts back up again, whenever that might be, which, yeah.
Okay. And, we're running out of time, but I want to get this one question. And so what can stakeholders do? I mean, what would be your recommendations? And then I think we may have one more question, might be able to fit in one more question. As a matter of fact, hold off on that one.
Okay, I see the one about right to counsel in New York City.
Exactly.
Yes, it's encouraged and it's being phased in. So someone else
Should I read the
answered it,
question?
right.
I'll just read the question. It says, is there now a right to counsel in New York City Housing Court for income eligible people? And you just answered that. What if you lost your job during the pandemic, but not because of it? Can you be evicted?
Well, I mean, who knows if it was because of it or not, right? You've had a financial hardship during the COVID-19 period.
Okay.
So you can document your income before and after, before and during. I mean, who knows, it might have tangentially been related to COVID anyway. There might be other issues. They will look at whether you qualified for benefits, for example, unemployment benefits or other agencies. So.
Okay. And now the question as far as what can you do? What can stakeholders, what can funders do? What can politicians do? What can people who are not necessarily directly impacted by this, what can we do?
Good question. I mean, being informed is super important. Knowing the potentially catastrophic consequences to our community as a whole if we were to have a huge number of evictions, and I think that's what has guided New York State, which is great. Understand that apparently the Departments of Social Services have been completely overwhelmed and have a huge backlog of people who are looking for benefits during this time and may or may not get the money that they're expecting to get from the federal government that was supposed to arrive in August and apparently may show up October 1st. We don't know because funds are I'm not exactly sure what's happening there, but it hasn't arrived yet. I know in Syracuse alone, there are well over 1,600 people on the wait list for help. So it's huge just in our city. And we will share what we can. Let's see. Yeah. Oh. I see this question on here. I'm sorry. People, there's a question about, things have changed because prices have gone up. We have more expenses, even if our income is the same. And I think that that's, important to be aware of and to bring up to the court. But right now, I would say the two most important things are get legal help because things are changing by the minute, and understand that as much as we have fought for rent to be waived, it hasn't happened. So rent is still due, but you cannot be evicted for non-payment if you meet the qualifications, which are more limited than I think people originally thought.
Okay. Well, we're running out of time, Laura. I think I've learned a lot from this, and I really appreciate you taking the time to inform a lot, judging from some of the comments that were also in with the questions. It sounds like a lot of people also benefited from this webinar. So I want to thank everyone for joining today's webinar. Don't forget to sign up for the Foundation's e-newsletters on our website and follow us on Twitter to help keep us up, keep you up to date on the latest work of the Foundation. And as I mentioned, we will be sending out a recap with a recording of today's webinar. And additionally, we will include a lot of the materials and links to the materials that have been discussed. Once again, thank you for attending and have a great rest of the day.
Thank you, everyone.